what I find interesting about the way that the sole arbitrator discussed this particular point was ignoring almost in its entirety the fact that the guidelines are only supposed to apply during competition for expressions of this kind. So I found it strange that she almost ignored the fact that there's a very strong argument that the guidelines don't apply to Heraskevych's situation because he was not allowed to compete, so he didn't have the opportunity to breach the guidelines in the first instance. So the way that the sole arbitrator addressed that was then to talk about it was an imminent breach because he had said that he was going to wear the helmet, yet up until the point that he actually starts the competition or his role in the competition, the guidelines also allow for expressions to be made between the changing rooms and before the start of the competition. So once again, he could have been able to change his helmet right at the last minute. And all of that was pretty much ignored. There was just a discussion that said, okay, the guidelines don't. And there's admissions from the sole arbitrator within there that the guidelines don't fully cover the situation that we're in or cover them at all, really. But then they tried to get around that by saying that the breach was imminent, yet again, we don't know that the breach would be actually likely to occur until he takes to the ice to go down. So that was my first concern with them. There are many others, particularly around the transparency of the entire process and the way that the sole arbitrator brings in that the IOC disciplinary commission were involved, but this wasn't a disciplinary issue, that this wasn't a sanction, so there's nothing to appeal against. And it drew out a whole load of procedural issues that we possibly weren't aware as to how this worked previously. And none of them are really given any airtime by the sole arbitrator in the way that she dealt with all of this. It's very much an opinion, an award here that is geared towards ensuring that the suspension was upheld rather than a deep dive into whether or not it should have been imposed in the first place.
First of all, I think it's super interesting that we have an award. In most of the past cases, there was no appeal, there was no award. We have very few awards in general that are related to freedom of expression and its restriction at the Olympics. So first of all, we have an opportunity here. It is to actually discuss a legal decision. As far as I understand, and we might go into that later on, Heraskevych has already announced that he would like to challenge that award. So it will continue giving us opportunities to discuss the scope of the IOC's right to restrict freedom of expression. This is what this case is fundamentally about. It's about a private organization with governance power deciding to restrict during a certain time and space the freedom of expression of an athlete. Most assume that this would be based on Rule 50, Rule 52, that political propaganda was being challenged in a way. What is interesting is this is a case that is not about Rule 50. And clearly, it is said in the award, you will find it at paragraph 81. This is not about Rule 50, it's about Rule 40 and Rule 42 in particular, the guidelines on freedom of expression that are supposed to be connected to Rule 42, and that have, and this is what paragraph 81 says, a wider scope than the concept of political propaganda. And this is already an interesting dimension. It's the IOC, in a way, extended the scope of restriction on freedom of expression through this case compared to what we thought was a restriction beforehand, which was very much focused on political propaganda. And the question was always, what is political propaganda? When are you engaging? This question is entirely absent in the award. So that's, and in a way, and that was also the title of the press release. I really loved it because there was some strong Orwellian touch to it. The CAS ad hoc division finds freedom of expression guaranteed at the Olympic Games, but not on the field of play. And it's basically saying you have freedom of expression, but actually you don't have freedom of expression at the main space at all where you are going to be visible to the world, where your expression will matter. And at this point in time, it's not anymore about political propaganda. It's not anymore about, it's about all expression, all individual views. And it's interesting as a development. It's also quite frightening because at this point in time, in the guidelines, you will find absolutely no definition of what expression means. So from a legal reasoning point of view, this decision poses already internally an issue in terms, in particular, of the principle of legality. The fact that if you are to be sanctioned, you have to know very well in advance when you are going to be sanctioned. And in this case, it seems, first of all, it's not clear that you are going to be sanctioned when you violate those guidelines. It wasn't really connected to an express ban like Rule 50. Rule 42 is about the freedom of expression. It's not about restricting your freedom. So it's a bit strange that you could construct a sanction here. But in addition, it seems very unclear what type of expression is to be sanctioned. And there it is very unclear also in comparison to past expressions. We had the cases of the Algerian athletes during the opening ceremony of the Paris Olympics throwing roses, which was a clear sign of remembrance of people who died in a very controversial context, if you know the history, who were not, as far as I know, excluded from competing ex post. Similarly, you had the Palestinian athlete wearing also in the opening ceremony a T-shirt that was highlighting the issue of the destruction of Gaza. Here again, we didn't get, while it was also in a way a symbol of remembrance of death and destruction, which we all know is extremely political in this context, there was no sanction. So again, this also poses a number of risks for the IOC, for the international federations, of creating also double standards or of clarifying what the standards are, because we see that these guidelines have been applied very differently in very different contexts.
I think the issue of inconsistency that Antoine raised is really important here, and the way again that the sole arbitrator dismissed that and simply said that 6 examples had been provided of other instances where the IOC had not taken action in similar situations, and simply said, I haven't got enough facts, so I'm going to ignore them. And again, it's very unusual for somebody to be quite so dismissive in that situation, because the kind of examples that Antoine gave, and there have been others in recent editions of the games, these are essential in terms of trying to determine whether or not there's been a breach. It plays into issues of reasonableness and proportionality as well, because as Antoine said, if you don't know what it is that is being regulated, then you can't regulate your own behavior to avoid breaching those regulations in the first place. So this inconsistency of approach is key. And it was interesting as well how much wider they did say, again, building on what Antoine said, they seem to say it was any expression. And within the judgment, within the award, it says that in reality, there should be no personalization of kit. In the IOC's letter to the Ukrainian Olympic Committee and to Heraskevych, it said that personalization was not allowed. Well, we've seen very clearly with many of the people wearing helmets at the Olympic Games, a lot of them had personalized them. And it would obviously take a lot of effort to determine whether or not they were all compliant with the regulations. But if we're saying that no expressions are allowed, then there's obviously a query that none of them should have been allowed. And also, why then are we picking on one person in this particular instance? So that lack of consistency, that lack of definitional clarity is absolutely essential if we're going to be if we are going to have regulations such as these. Then it needs to be very clear what it is that we're trying to restrict and how and why we're trying to restrict it.
The if is also very important. Do we need that type of regulation that is not even targeting any more political propaganda? It's just targeting individualization of expression of, what concerns you as an individual at a particular moment, remembrance of people that are connected to your society, remembrance of traumas from your society. Should this be banned from the Olympics? I think that's also a big question that this case is raising. But what Mark and I are saying is that even if we concede that, it seems that the regulatory system of Rule 40 guidelines is extremely vague, inconsistent, and problematic under the principle of legality. And then beyond that, I think we need to question, and the case is an opportunity to question how far restriction, and how far should the athletes' right to freedom of expression be restricted? Because and here we are entering more into the kind of proportionality analysis that is also conducted in a very, how to qualify it. I mean, I have understanding for the arbitrator. This decision has to come in something like a day. So not even a day. I think the hearing was in the morning, decision was rendered in the afternoon. I guess the award was drafted a little bit longer. So there is a limit to the depth of the argumentation, but this proportionality analysis is really bare bone, and would not appear as serious to a normal court, and is a problem in itself. But so whether this is proportionate is, I think, a question that we need to ask. Whether it is also, and in this regard, whether doing what was done by the IOC is an adequate way to attain what is claimed to be the primary goal: protecting the attention of the public on the sporting performance of the athlete. In fact, in this exact case, would Heraskevych have had the opportunity to wear his helmet? We would have spoken way less about Heraskevych and his helmet and way more about Skeleton. So paradoxically, what happened shows that this is not the right way to protect the focus on sports during the competition. And in fact, I would claim that it could be incentivizing athletes who want to make a point to do that, because they know they will be sanctioned and that they know it will create a commotion. So we have an issue also in terms of just, as you may know, in the proportionality analysis goes through different steps. The first one being the suitability, the adequacy of the measure to attain the objective. Just at this step, at this first initial step, which usually is not a problem in the proportionality analysis, we have already a big question mark. And then moving to the necessity and to the proportionality strictus sensu, we have even more question marks that come into play. So this is where also the bigger question lies. It's in this if of Mark. Should we just exclude any type of expression from the field of play, from the opening ceremony, from the medal podium. I think this case shows that this is a wrong-headed policy, in my view. Wrong-headed both from a kind of policy perspective. It brings only the IOC in disrepute and detracts attention from the Olympic Games. And from a legal perspective, it's not a proportionate way to try to avoid that there is uh, attention that is lost from the games, from the sporting performance, because of a helmet.
Clearly, there is no balance between the power structures, and it was as well. I think a lot of the issue here is about the transparency of the procedure that happened here, because although it appears that what's happened is that the IOC disciplinary commission took a decision, and then they informed the International Bobsled and Skeleton Federation of that decision, who then operationalized it by saying that Heraskevych could not start the race. So you have two decisions there that are taken in isolation from the athlete, and the athlete has no opportunity to challenge those, or even to be heard in the first instance. That his first opportunity to be heard is at stage 3 of this process, which is if he decides himself to take a challenge to the Court of Arbitration for Sport. So we've already had these decisions taken behind closed doors. It's not clear from what those decisions say as to what the legal basis of the exclusion was and the suspension was. And then he's expected to be able to appeal against decisions that have been taken without any involvement with himself in there. So in terms of the balance, what it's shown is that the IOC is still very much considering itself to be the supreme power of the Olympic movement and to be able to act in the way that it feels it wants to in any given situation. They've then enabled or facilitated the Bobsled Federation to actually take the decision, and only after that does the athlete then formally become involved in it. There's also claims from the Ukrainian Olympic Committee that the decision was taken around an hour and a half before the start of the event. So, in other words, way before the event itself has begun, and almost prejudging the situation rather than enabling the athlete to maybe have had a very last minute change of heart. So, in effect, he's been punished for an intent to break these regulations rather than actually breaking them.
It's a more like institutional governance dimension. So, who decides what in the Olympic movement at the Olympic Games, who regulates on whose behalf with what legitimacy. And to some extent, what we saw here is, first of all, it's a lot of executive governance. We also probably Kirsty Coventry crying and going there last time to give a last chance, bypassing her own disciplinary commission in a way. So this process was very executive led, which is also raising issues in terms of rule of law, separation of powers inside the IOC, and so on. 72 to 75. In this paragraph, the arbitrator does something that I think is fundamentally wrong. It is misunderstanding her function. In this paragraph, she argues that there should be a separation of power, and therefore she should not put into doubt policy decisions made by the IOC. What she mistakes is that this separation of powers has a sense when you're dealing in a democracy with a democratic legislature and potentially a democratic executive that is accountable to the people through other mechanisms. She might have overlooked the fact that the IOC is all but democratic and that the affected athletes have very little say in the policies of the IOC. They elect a few members of the IOC Athletes Commission, but they are diluted in a much bigger voting pool of people who are self-appointed and who are absolutely not accountable to athletes, while they affect immensely the life of those athletes. through their rules and decisions. And we have the vivid case of Heraskevych here, but this is true for all other athletes. And here I think the arbitrators made a fundamental mistake that is also contrary to the idea or to the underlying ethos of the Semenya decision of the Grand Chamber of the European Court of Human Rights, which is to say, well, you're dealing with a space that is very weird, in which you have a private organization which acts as a government, but is not democratically accountable, and forces athletes to accept rules, decisions, and so on. And in that space, it is essential that you exercise a particularly rigorous judicial review. That is what the arbitrator, in those paragraphs, has shown that she failed to understand. Her duty as an arbitrator dealing on appeal with a decision that was taken in such opaque and discretionary ways than the one that were just sketched by Mark. Her duty was not to exercise a light control, not to respect the legitimacy of the legislator or the administration. It was to exercise a strict control, even more so when you know that the athlete had no right to defend itself before that commission, but also has no time to prepare a challenge. She is receiving an athlete that had a few hours to prepare a submission. It is her duty ex officio to do as much as she can to check that decision, and not to concede from the outset that she has to be a bit hands-off because she's the judiciary. So that was a fundamental mistake of the arbitrator, really fundamental misunderstanding of her positionality. It does make sense from the point of view of an arbitrator that is highly dependent on the Olympic movement for her career. Highly dependent because, as you may know, the CAS is controlled by the ICAS, which is itself controlled by people who are nominated by the Olympic movement. And for a long time, you had the IOC vice president being the CAS president. And in fact, getting on the list of CAS ad hoc arbitrator is possible only with the consent of the ICAS. So it does make sense in that context that she prefers to adopt a different approach. Institutionally, the system is built to leave very little accountability for the IOC, for the international federations through the CAS, but also through democratic mechanisms. That these guidelines were consulted, that there was a massive consultation of athletes 6 years ago. I think you could deconstruct the quality of this consultation, who was consulted, was it a representative one, etc. Let's not go into that. But this consultation, this minimal consultation, cannot replace a democratic structure led by an executive. A consultation led and paid for by an executive is not equivalent to a democratic election and to decision making by democratic representative or by representative of the athletes. So there is where things are going wrong in the award, and where the award connects also to the much wider world of the governance of international sports, and opens up different questions that are, I find, super interesting, but that are also very important in terms of how do we govern sport and who plays a role in that governance. So, I mean, I think it's pretty obvious, again, that the first choice that is going to be made by his legal team is whether to go to the Swiss Federal Supreme Court to challenge the award in setting aside proceedings. And we'll see how the Swiss Federal Supreme Court will react in light also of the Semenya decision. The issue that he might face is that there is no real remedy anymore for his case. The run has happened. There is no. The question will be whether he has still an interest in continuing to challenge that award. That might be an issue. However, what he could also do, and I think he has not considered it yet, but it could be an interesting option, would be to ask for damages. To do a bit like Diarra in a football transfer context, and to say, well, I wasn't allowed to participate, I wasn't allowed to enjoy, to have a chance to win a medal, I suffered a damage. And I suffered a damage that is material, moral, my reputation, etc., etc. And this damage is based on a wrong by the IOC, which is a violation of EU competition law. And that he could do and bypass the CAS and go to Italian national courts to do it. And that would be an interesting case to try to push forward, which I think would not face the risk of being found procedurally moot, because there is still an interest, there is still a damage, and which could raise through the intermediary of competition law the question whether those rules are proportionate or not, potentially up to the European Court of Justice. So that's the second route that I think is not being entertained at this point by his lawyers, because they are not really aware of that route, or they are not really, it's not really the intuitive one. But it's an interesting option for him. I think they will definitely go to the Swiss Federal Supreme Court and try to at least get the award annulled. And that might happen if the Swiss Supreme Court adopts a strict review again and goes into the depths of the proportionality analysis. My intuition would tell me that it's very unlikely. The Swiss Supreme Court has proven a very, very reliable ally of the Court of Arbitration for Sports for more than 30 years. And I'm not sure they are willing to entertain the possibility to do a real review. But it would also be a door opener to go then to the European Court of Human Rights, which, if there is a decision of the Swiss Supreme Court that is negative for him, he could then go to the European Court of Human Rights, and that might be actually the real place where he wants to land, to actually raise the fundamental question of the freedom of expression at the Olympics. So that would be a very interesting case if he has the resources to pursue that case, because here we are talking about at a minimum 5 years, more likely 10 years,
I think that it will be something to do with the willingness of the Swiss Federal Tribunal as well to decide whether or not they actually want to go down this route. And what it's demonstrating, and that was the if that I used earlier, is that there are two big questions here. One is about applying those guidelines as they are in existence at present, which, as I opened by saying, I don't think that they have done that in the correct way. But then the more fundamental question is whether these guidelines should be in existence in the first place at all. And certainly from the work that we've done in this area, it will be extremely interesting for this to go up either to the Swiss Supreme Court or to the Court of Human Rights, to see how they think that the Semenya decision should actually have been implemented in this case, because the 3 or 4 paragraphs that the sole arbitrator spent analysing Article 10 isn't really going to be considered to be a particularly rigorous analysis. It's very much a case of they've got lots of opportunities to express their opinion. He didn't avail himself of those. Therefore, he's the one that's at fault here. the restrictions are okay. That really isn't engaging with what Article 10 itself says, and certainly not with any of the jurisprudence on freedom of expression.